Welcome to week 2 of LE 200, Legal Research and Writing for Paralegals. This week, if you have your syllabus handy, we're going to be talking about the federal and state court systems. And this slide is taken essentially from your syllabus, but you need to read Chapter 2 in the Legal Researching and Writing for Paralegals. And also, please review and familiarize yourself with the ALWD Manual, Part 2. It's pages 9 through 54. They're small little pages, and I don't mean read it word for word, but go through and kind of skim and get familiar with the material that is in there. So you don't have to sit and memorize or take notes on everything, but do kind of take a look at it all. Complete the weekly quiz. There is only one quiz this week, the Legal Research and Writing quiz, and post to the weekly forums. And I don't have this up there, but make sure you complete your weekly assignment as well. That is listed under assignments on the Sakai site too. So I will... We are looking at the Sakai site, and so if you click under assignments, you have your week 2 assignment as well, which is some of the questions from here. And you can use Westlaw to do that, or you can just use the internet in general. You should be able to find most of the information. And if you do not have Westlaw yet, we are working to get you that. And then you should have completed the Aspen Quiz 1 and the Legal Research and Writing Week 1 quiz, and Week 2 quiz is up and available. And under Resources, you will find the PowerPoint that you're looking at right now, as well as a link to the YouTube presentation that you're watching as well. So apparently you would have found that. Okay. So, first I wanted to just review the concept of federalism. Hopefully everything in this chapter really is a review to you. You should have kind of mastered it previously in the program and in previous courses. If you don't kind of know it by heart by now, then please take the time to make sure you learn it and review. Okay, so just a quick history lesson on the United States and how we got where we are in terms of our government structure. It could start earlier than this if you wanted, but our Declaration of Independence was signed in 1776, July 4th, when the United States declared its sovereignty from the United Kingdom. And from there, our first attempt at a government was called the Articles of Confederation, which was an alliance between the then 13 states to essentially work to not get in each other's way, but have independent governments. And that really did not work well because there needed to be some sort of unification. Problems that were occurring were each state was issuing its own kind of money and then not accepting the other state's money. And there were problems of trade and delivery and things going across borders and not having a cohesive military in terms of protection and all sorts of issues. It just didn't really work out. And the document itself actually didn't include any provisions for correcting, changing, making improvements. So the Constitutional Convention that was actually held in secret in Philadelphia in an attempt to create a better system. And that ultimately resulted in the U.S. Constitution, which is a big source of compromise. You had people that wanted a strong national federal government, and you had people that wanted strong states with limited federal national government. There was the fear of having another king, like in England, and they didn't want control from some central location that was very separated from where they were. So now we're talking about the 18th century. Travel was not what it is today. It's not like you could just hop on a plane and be across the country in a few hours. Back then, travel was, you're talking like wagons and by foot. So if you were a state like South Carolina and then you had a central government in New York, then you would be facing a very similar issue to what the problem with England and having a king governing from abroad. You weren't localized, didn't know the issues. So there were big state rights advocates that wanted to make sure that government was kept local to where they were. But then there were other people that realized the importance of having, that national federal government, and the Articles of Confederation illustrated the problem of a lack of cohesion amongst the states. So you had kind of two parties at play there, and ultimately they ended up with a compromise that is the system of government that we have today, our system of federalism, where the power is split between a national government and between states. And another part of that compromise was the Bill of Rights. The states wanted to have the Bill of Rights, the first 10 amendments to the Constitution, put into effect almost immediately, and it was within 2 years of passing of the U.S. Constitution. So, I guess before we get there, we established, so we have the 50 state governments, and then we have the federal government as well. So power is basically, the 10th Amendment says anything not specifically delegated to the federal courts is reserved to the states. So anything that the Constitution does not specifically say, hey, the federal government has power here, then the rest is left up to the states to do as they choose. Federal legislation is also allowed to come in to preempt any state activity in certain areas, but for the most part, a lot of things are left up to the states. So this week we're talking about federal courts, and those were established in Article 3 of the Constitution, which you can look at. It basically says that the power will be vested in one Supreme Court and such inferior courts as the legislature deems necessary. And so we have our Supreme Court of the United States, and we have our United States Circuit Courts of Appeals and our district courts. Jurisdiction. Jurisdiction of the federal courts is limited. You cannot just file any case in federal court. You have to either have federal question jurisdiction or diversity jurisdiction. Federal question jurisdiction is a question arising under federal law. So some statute that the legislature has passed, or the federal legislature, or some question arising under the Constitution. If you have one of those, then you can file in federal court. If it's not one of those, then the only other way you can get into federal court is through diversity jurisdiction, which means that you have two parties from different states. So like a citizen of New York is suing a citizen of California. You have to have complete diversity, meaning that everybody on the plaintiff side is completely diverse from everybody on the defendant's side. So if you have multiple parties on either or both sides, everybody has to be diverse. So if you have a plaintiff that's from New York and a plaintiff that's California, and the defendant is also from California, you would not have complete diversity because you have two residents from California, one on each side. So you have to have complete diversity, and you also have to have more than $75,000 in dispute. So you can't sue for $75,000, you'd have to sue for $75,000 and a penny in order to qualify for diversity jurisdiction. Jurisdiction is basically that power of a court to hear a case, and that's the main way that it is used. You might also see in LE 101 we talked about personal jurisdiction and interim jurisdiction and subject matter jurisdiction. Jurisdiction can also be like that geographical area from which you fall. Like if you live in the state of West Virginia, then you're subject to the jurisdiction of West Virginia by virtue of living there and being a resident. So whether or not a court has personal jurisdiction over you is kind of a separate issue. And then here we're looking more at issues of subject matter jurisdiction. Concurrent jurisdiction is when two courts have the power to hear the same case. So you might have an issue that occurs and there is a federal law that is applicable and a state law that is applicable. That means that you could file the case in either court because both of them have jurisdiction over it. There are certain areas where a court will have exclusive jurisdiction. So a bankruptcy court. So if you're going to file for bankruptcy, the bankruptcy courts of the United States have exclusive jurisdiction over bankruptcy matters. Okay, ground rules for a case. Before you can file a case, you have to have an active, ongoing controversy. Otherwise, the case is said to be moot. It can't be something that is resolved and you want to come back at it. It has to be an active controversy. I have noted there, and the text talks about an exception that was made in Roe v. Wade, which was the abortion case in like 1972, I think. And the time it takes to process a case through the courts is longer than it takes for a pregnancy to come to fruition. So there was an exception made for Roe v. Wade because there would never be a situation in which they could hear the case if they required it to be an act of controversy. But generally speaking, you have to have an act of controversy, otherwise the case is said to be moot. Standing. You have to have a personal stake in the outcome of the case. You can't just see that your buddy Bill was ripped off by Joe down the street and you want to sue on his behalf, because that's just not right. You can't do that. You have to have a personal stake in the outcome of the case. Something has to have happened to you. The Sierra Club versus Morton case that's cited there and talked about in your text was an environmental case that was filed dealing with the destruction or I don't remember, something dealing with like a I think like a mining field, that kind of thing. So a club, a nature club that supports nature, was seeing a mountain destroyed and they wanted to sue, but since they didn't own the property there or have any direct link to the case, it was found that they lacked standing to do so. So you have to have that personal stake or that personal outcome personally involved in it in some way. Okay. Federal court structure. The trial courts of the federal court system are called the district courts. There are 94 of those. There is a map, I think in Chapter 8, your text references the specific one that you can see how the district courts are divided up. And it's basically a matter of like need population. The West Virginia has 2 district courts, whereas one of the bigger states would have several more, and some of the less populated states would have less. The United States Courts of Appeals are the second tier. If you look at page 41, you can see a map of the United States and how the courts are divvied up, how the circuits are divvied up. And if you look, you can find West Virginia there in the 4th Circuit Court of Appeals. These courts are appellate courts. They do not retry cases. They only review for prejudicial error made in the cases below. And United States Courts of Appeals also review and enforce decisions from federal administrative agencies. So they are not trial courts. They don't hear the case. They can only review cases, so they can't take in new evidence. And then the U.S. Supreme Court, if you look at page 46 in your text, you will see figure 2.3, and it reviews the different ways that you can get into the United States Supreme Court. The primary way is appellate jurisdiction, so appeal from either one of the state Supreme Courts or the United States Circuit Courts of Appeals, one of those. But the United States Supreme Court can also have original jurisdiction over certain controversies, and those factors are laid out there in figure 2.3. Figure 2.4, if you flip to page 51, shows you kind of the structure, how the process works for federal courts with the various courts at the bottom. You can find United States District Courts there. That's where a lot of things are going to happen, but there are other specialized courts depending on the issue you're dealing with. And up there on the side, on the top left, shows you kind of a state court structure. And note that some state courts have an intermediate appellate court, and others do not. They just have the trial court that goes straight to the Supreme Court. And those decisions could be appealed to the Supreme Court. Okay, there are examples in the text of state court organization, and previously we have talked about the different structure of West Virginia. And if you we're back in Sakai right now, so you're under resources, and if you look at, I'm in the PowerPoints right now, go up to resources in general, you will see a link here to state court structure charts. And so this is a project from the National Council for State Courts. And you can see our map here, and you can click on West Virginia or whichever state you want to learn about, and it shows you the structure of the court system. So in West Virginia we have magistrate courts, family courts, municipal courts, and then circuit courts, and our Supreme Court of Appeals. And this is a nice little reference site to give you what type of cases, how many judges, etc., that these courts can hear. One thing about the family court can appeal to the circuit court. The family court can also appeal directly to the U.S. Supreme Court, if you remember that. There's also a link to the U.S. Court's homepage, which you will have to use, I think, last week, but maybe this week, to answer some of your questions, and you can find out more information there. Okay. Let's get back to where we were. Oops. That's the last one. Okay. Well, so we just kind of looked at that. And then citation form, it starts talking about citations in general in your text this weekend, the Blue Book and the ALWD manual. We have the ALWD manual, which is similar to the Blue Book, but much more user-friendly. I think I talked about that last week some. But the importance of citations, we have to have a uniform method of citations so we all know what each other, what we're talking about, and can reference and find the things that we need. Okay, I think that is everything for this week. Let me know if you have any questions. Thanks.